This is David for 10 on Tactics for Tactics and Trials.com. Today, we are going to review the 2001 case of Deorle vs. Rutherford, 272 F3D 1272. This is an older decision from the Ninth Circuit Court of Appeals, but it is still good case law in the circuit. Please remember to subscribe to the channel and leave any questions or comments below. The issue addressed in Deorle was whether a deputy's use of a cloth-cased beanbag round against an advancing suspect, Richard Deorle, constituted excessive force under the Fourth Amendment, and whether the deputy was entitled to qualified immunity. The Ninth Circuit held that based on the record before it, the force used by the deputy was objectively unreasonable, and that qualified immunity was unavailable at summary judgment. The panel concluded that the totality of the circumstances showed Deorle posed no immediate threat justifying the degree of force used, and that, where feasible, warnings and less intrusive alternative methods of compliance must be considered. I thought it would be insightful to see what facts the court found important in their decision. The statement of facts is stated by Judge Stephen Reinhardt, the author of the opinion on or about September 6, 1996. Richard Deorle was upset at being diagnosed with hepatitis C. Deorle consumed a half pint of vodka and took some interferon, and he began behaving erratically. Deorle became suicidal and had lost control of himself, according to his wife. Deorle began screaming and banging on the walls of their house. The police are called by the wife to help her husband. Upon arrival of the deputies, Mrs. Deorle and the children leave the house. Deorle does not attempt to stop them. A deputy escorts them to a house down the road. Deorle refuses to let the deputies enter his home. 13 deputies respond to the emergency request for backup. Upon their arrival, the deputies set up roadblocks on the streets around the house to ensure that Deorle had no avenue of escape. The roadblocks were used to contain Deorle's movement and prevent his escape. Multiple officers observed him roaming on or about his property and along the road, walking back and forth between the roadblocks and returning to his residence. According to the court, the SWAT members are trained to arrest suspects in the most efficient and least hazardous manner, and arrest suspects with a minimum amount of risk or danger to the suspect. The court found that Deorle was verbally intimidating, but he was physically compliant and followed all the officers' instructions. For example, when a wooden board from the porch railings came away in his hands, portrayed as if accidentally falling into Deorle's hands, Deorle dropped it at the officer's command. Although shouting, "Kill me," and brandishing a hatchet at a police officer, he threw the hatchet away into a clump of trees when told to put it down. When a canine team tested his behavior by making their dog bark aggressively at Deorle, he retreated towards his house. Officer Rutherford, who was at the scene for 30 to 40 minutes, did not observe Deorle touch, let alone attack, anyone. Deorle did scream at the deputy that he would kick his ass. Deputy Rutherford was a member of SWAT. He was trained in the deployment of force against recalcitrant suspects and had arrived on the scene in response to the emergency call for service. After a briefing by his superiors in consultation with another officer on the scene, Rutherford decided to reconnoiter closer to Deorle. He was also aware that the negotiators had not arrived on scene yet. Rutherford observed Deorle for about 5 to 10 minutes from the cover of some trees before Deorle, carrying an unloaded plastic crossbow in one hand and what may have been a bottle of charcoal lighter fluid in the other, started shouting at the officers. Rutherford was armed with a 12-gauge shotgun loaded with what appellees term a less lethal or beanbag round. These rounds are made of lead shot contained in a cloth sack and are small enough to be fired from a shotgun. The rounds could have lethal capabilities at 30 feet and are potentially lethal up to 50 feet. In response to Deorle's taunts, Rutherford shouted at him to put down the crossbow, and Deorle discarded it. According to Rutherford, Deorle then walked directly at me at a steady gait. He didn't run at me. He didn't take his time getting to me. It was just a steady walk directly at me. Once he started walking towards me, I took a little wider stance with my feet to get a good stable base. As I leaned my weapon up against the tree to make it more stable, and I focused on his lower right rib area as he was walking towards me for a target area. During his deposition, Rutherford testified that roadblocks were in place and that he knew Deorle was contained and that other officers were stationed at each intersection. Rutherford also testified that his line of retreat was clear and that he believed his position was secure. In his deposition, Rutherford initially told a sergeant that he fired because he believed Deorle might take a neighbor hostage. In his later deposition, he stated he fired because he believed Deorle would pass him and thereby pose a menace to Rutherford, the officers, and neighbors. At a point when Deorle was walking in an easterly direction on his own property toward Rutherford's position at a steady gait, Rutherford waited until Deorle reached a predetermined spot behind a tree and then discharged the beanbag projectile. Rutherford did not issue a verbal warning, nor did he instruct Deorle to drop the bottle or to stop moving. The record shows at best that another officer may have shouted, "less lethal," immediately after the shot, but nothing given to Deorle in advance in terms of warning. In his deposition, Rutherford initially told a sergeant that he fired because he believed Deorle might take a neighbor hostage. In his later deposition, he stated he fired because he believed Deorle would pass him and thereby pose a menace to other officers and the neighbors. He also acknowledged he had commanded Deorle earlier to drop the crossbow, which Deorle did. The cloth-cased shot struck Deorle in the face, knocked him off his feet, and lodged half out of his eye. He suffered multiple fractures to his cranium, the loss of his left eye, and the lead shot was embedded in his skull. I think there were certain key issues that the court focused on in their opinion. 1. Has Deorle committed any crime? It is his home and he has not threatened his wife or family. At all times he is on his property. 2. What was the urgency justifying the request for additional units with lights and sirens? Again, what crimes have been committed justifying the use of these resources? The court is finding that there was ample time to use resources. 3. When the officer fired the beanbag round, he never gave a warning. The court identified the important issue of providing a warning before any application of force. This has been a recurring theme with the Ninth Circuit. Provide a warning prior to any application of force, if feasible. 4. The entire encounter from when the first deputy arrived to when Deorle was shot with a less lethal round was a total of 45 minutes. The court found no urgency in the call for service and recognized the passage of time. Plaintiff Deorle filed suit alleging excessive force under 42 U.S.C. Section 1983. The district court granted summary judgment for the defendants. The Ninth Circuit reversed in part, concluding that material factual disputes remained. The matter was remanded. The Ninth Circuit applied the well-settled analysis from the U.S. Supreme Court case from 1989, Graham v. Connor, 490 U.S. 386. The reasonableness of force is judged under an objective, reasonable standard that is based on the totality of the circumstances, considering factors such as the severity of the crime, whether the suspect posed an immediate threat to the safety of officers or others, and whether the suspect was actively resisting arrest or attempting to evade arrest by flight. Graham requires courts to evaluate such claims from the perspective of a reasonable officer on the scene. Deorle further emphasized a few other considerations. 1. Did the officer have any reasonable alternatives available aside from a severe force application? 2. If the officer uses a less lethal compliance device, was the device used pursuant to its limitations? 3. The court has also directed that officers should consider a suspect's emotional and mental condition when assessing to any intervention. The court stressed the following points in their analysis. 1. Immediate threat and objective reasonableness. The court reasoned that objective reasonableness depends on whether the suspect posed an immediate threat to the officers or anyone else. Although Deorle sometimes yelled threats, the panel found that the record did not show he presented an immediate, particularized danger at the moment Deputy Rutherford fired the beanbag. The court observed that Deorle was unarmed, had not attacked or even touched anyone, had generally obeyed the instructions given to him by various police officers, and was walking at a steady gait rather than charging or running at the deputy. Under those circumstances, based on the facts as presented by Deorle, the use of a less lethal round to the face was not an objectively reasonable application of force. 2. Warning and consideration of less intrusive alternatives than the beanbag round. The Ninth Circuit emphasized the importance of officers providing warnings before applying force. The panel stated that a desire to resolve quickly a potentially dangerous situation is not the same as an immediate threat that justifies force, and made clear that where officers have time and alternatives, distance, cover, verbal persuasion, or less injurious options, those measures bear on whether force is necessary. In addition, the court criticized the absence of an effective warning immediately before deployment of the beanbag shot when circumstances permitted giving one. 3. Sequence and duration of contact. The panel also relied on the fact that officers had observed and interacted with Deorle for an extended period, 30 to 40 minutes, before the beanbag was used, which made the situation distinguishable from split-second decision cases where the officers did not have the luxury of time. The court reasoned that the passage of time here increased the officer's ability to use alternative methods to gain compliance, and that this temporal context lessened the degree of deference owed to an officer's claim of an instantaneous perception of danger. 4. Qualified immunity. The Ninth Circuit held that the law was sufficiently and clearly established to put an officer on notice that using a less lethal projectile in that manner against an unarmed, non-assaultive individual in these types of circumstances could violate the Fourth Amendment. The panel explained that earlier Ninth Circuit precedent had made clear the multi-factor Graham analysis and the importance of alternative methods of compliance and warnings in assessing the necessity for any use of force. The panel concluded that viewing the evidence in the light most favorable to Deorle, the force used was excessive, and the officer was not entitled to qualified immunity as a matter of law at that procedural stage, summary judgment. Significance and subsequent treatment. Deorle is a leading Ninth Circuit decision on less lethal force and the duty to consider warnings and alternate methods of compliance when circumstances permit. Courts in the Ninth Circuit regularly cite this case when evaluating force used against an individual that is described as emotionally disturbed or mentally ill. The case is frequently invoked in qualified immunity litigation to show that the law was clearly established for certain fact patterns where officers used force against allegedly mentally ill but non-assaultive subjects after an extended period of observation, no urgency. The biggest takeaway from Deorle is to inquire if the individual is committing a crime, and if not, then law enforcement should direct the call for service to a medically trained unit, licensed doctors or medical personnel, capable of managing any emotionally disturbed individual. The unfortunate truth is that this type of scenario is not best suited for law enforcement. This is David for tacticsandtrials.com. Until next time, be safe.